Good afternoon, all panelists, dear participants. Good afternoon. Am I audible to all?
Yes, sir. Yes, sir, you're audible.
Okay, thank you, madam. Thank
Good
you.
afternoon, sir.
Good afternoon. Just let us have a recapitulation of what we have done yesterday. In fact, today is the 4th day of our FDP, and all the days we feel that is very interesting, and there are a lot of interactions. So learnings are very high. Yesterday, Mr. Shailendra Bhandare, he has explained us, he has nicely explained us what is a trademark and how we can utilize for our, if those who are having startup, how we can utilize that. How we can utilize that. So that yesterday we have discussed about the trademark. And then Dr. Dhananjay Saha has given lot of insights. He has clearly told that before we start the patent, first you have to do the patent search and find out whether that is really a patentable item. And once that is done, then he has explained us how to write a patent document. And very clearly, yesterday's session was very interactive. So today is the 4th day. See, today our first speaker is Mr. Saurabh Trivedi. He is investor, mentor, speaker, business consultant, seasoned trademark attorney, co-founder and director at Boudhik Ventures Private Limited. Mr. Tiwari, he possesses unique set of skills and enterprise and experiences that allows him to gain a quick understanding of the industrial process. He is passionate and well-respected leader with ability to define and drive business strategy, motivate team, aggressively execute and analyze impact. He inspires and educates business on how to leverage their innovative concepts to stand out from the mass and gain traction. Legally advising to startup, corporates, innovators on various issues related to intellectual property and has extensive experience in all respects of intellectual property law with special emphasis on filing, prosecution, and enforcement of trademark, copyrights, and design. He also guides young entrepreneurs, startups, and early stage business to align the process, resources, planning, and developmental goal with overall strategy. He also provides support and insight into significant organizational changes. He worked with international law firms for supporting innovators to protect and expand business globally. Today, his topic is types of IPR, its importance and benefits for universities and investors. So I request Mr. Saurabh Tiwari to proceed with his speech.
Thank you, Mr. Paul. Thanks a lot for this wonderful introduction. And you told a lot about me on this intellectual property and how exactly I have been introduced in this startup ecosystem. So I just started from a long background where I was working with lots of international law firms. And in international market, these all the awareness are lots in terms of filing a patent application to file an invention or innovations. But when we talk about India, there's a less awareness in terms or comparison with the international market. But yes, in real grounds, we do have a lots of innovation. But how we are going to protect it, we don't have any knowledge about the same. Sometimes when I talk with university professors or teachers or the PhD aspirants who already published a lots of research papers and which is available for the industries to use them without giving some kind of recognition to the professors. But yes, on the other ground, the research papers definitely give some kind of importance in their NIRF, which is really important for them to have some good positions. Apart from that, they didn't get any kind of value assigned with their research work. So it's really important for us to understand how this intellectual property help us to protect our research work protect our innovation, protect our products, protect our technology, whatever we do have as terms of intellectual capabilities, intellectual ideas. So now the today's topic, when I'm talking about this startup ecosystem, so I work with lots of the startups or lots of professors in filing the patent applications, trademarks, copyright designs, but how things can be sorted out and what are real intellectual property they required, either it has been important for them or not, so they are going to identify. I'm going to start it with some common types of IP. I think previously some of our similar kind of people has been taken some important topic covered, and I think patent or prior art searches. So I'm going to give you overall structure, a brief structure, what are common types of IP, and in a very layman terms. Whenever we do have a good technology, the product, the functionality, the process, if we think that this is very innovative and disruptive in the market, we should go ahead and file the patents. There are two types of patent application drafting. Even I think one of the previous speaker, which Mr. Paul told us, that he already explained what to be covered under the part. Okay, so there are two types of drafting has been there: provisional patent application and the complete patent application drafting. So it's entirely on the person, the inventor, who think that they should go ahead and file the provisional application because they are not ready with the complete thoughts or the scope or the claims which they are going to claim. So it's really important to file a provisional application when you are in a hurry and you are going to disclose any idea to any investor or big giants to take your solution. Then you just go ahead and protect under the provisional drafting and filing the application. Complete when you think that you are in a positive side and the claims which you are going to write really important for you, you can just go ahead and file the complete patent application. Another very important thing, whenever we talk and start our process, then we need some kind of credibility. Credibility in terms, in eyes of the investor, in eyes of the persons where we are going to start our business. And we just wanted to attract the customer or getting a huge traction in our business. Then we should go ahead and file that unique design logo or a word mark under the trademark provisions. We can file it and protect our intellectual assets, because we think that we have designed a wonderful logo. We think that this technology we have invented, we can go ahead and file patents. So in intellectual property, the assets which you have created, which you have thought in your mind, is really important and to secure, because it's similar to a tangible assets, but in the form of intangible assets, and all sorts of rights is similar as human property. So you can go ahead and design a wonderful mark, you can file under the trademark application. Third part, a copyright. Whenever we do have a wonderful literature, wonderful artistic work, musical notes, codes, computer softwares, this is the provision under the copyright that you can file it, just to showcase to people that this is my copyright, I have published this, so I am going to claim it, this is my intellectual property. So any literary work, artistic work, dramatic work, go ahead and file under the copyright design. Another important type of IP is a design IP. When you have a wonderful product and you think that the looks of that product is really important, is very unique, you can just go ahead and file under the design registration. Sometimes people get confused by the name of design patent. But design patent is a term used in US Patent Office, not in India. In India, it has been known as a design registration. So this is really important for us whenever we can go ahead and think to protect our intellectual assets. And these are your assets because you have done this research part. So How to protect it? Because you just have some kind of thoughts that somebody is going to replicate, somebody is going to use it freely, but I don't have any right on the same. How I can claim it? That is why this intellectual property comes into picture. And there's a different sections you think your assets can file in right type of IP. Last but not the least is geographical indication. I think we people know that whenever we hear the Pashmina, Kashmir territory comes into our mind. Whenever we heard about oranges, Nagpur comes into our mind. So the product or the commodity of a state itself defined a geography that has been protected under the geographical indication. So these are some common types of IP, but yes, apart from this IP, everything is not IP. Sometimes our business is really important where we can keep them as a trade secrets. This is my property, but I have no provision to secure it, only in the form of contract or agreements. So this is the overall common types of IP, wherever you can just think yours, what you have done, carefully analyze this, and then accordingly protect under the similar type of IP. Now the next part comes whenever we talk about we should go ahead and file the patent application, we should go ahead, file the trademark application, that's okay. But what exactly this intellectual property gives to me? I'm a professor, what exactly the benefits for me to file a patent application? I think of to start a business, but how exactly this intellectual property worth for me? So these are some benefits whenever I talk with this startup ecosystem or startup people or the person who wish to start their own, I'm talking these benefits. This is not what it is probably things, but it's a tool. Intellectual property is a tool for doing a business, for easing a business, to expand our business in different countries. First benefit out of this intellectual property is a power. If you have your patent applications filed, then you do have a power to eliminate your competitors. Competitors that the similar kind of things they are not going to do. They do have certain fears in their mind that they have already filed as an intellectual property. You heard about the prior art searches, which has been performed before drafting a patent application. That prior art search, why exactly we are going to do? We have to identify that we are not going to work on the concept which has been already disclosed, or we are not going to reinvent the wheel. But once we do have this intellectual property in our hand, we have power to eliminate my competitors. Then the second part is credibility. When I'm talking about the business's perspective, when you have IP, some investor wish to put money when you have your assets. But if you are showing that we do have this idea and we have not done anything apart from that, make a pitch presentation on our idea that how exactly this is going to work, but we have not protected. So I think investor is having some fear that I'm not going to put my money because it's also on paper. Apart from that, you don't have any assets. Whenever we talk about the accounts, everybody heard about the accounting side or the liability side of a balance sheet. So if you do have a proper intellectual property, I think you can cover under the assets part. If you have your brand name registered, you do have a strong credibility in terms of consumers. You should differentiate your brand in the form of doing any kind of business, either in a B2C sector, B2B, B2G. You can have your credibility because you have patents, you have filed that trademark applications. Then the third thing, on this intellectual property, you can do your business. As a professor, I think you can innovate more. You can file patent application. You identified or picked a topic on your research, but you don't wish to start your startup. You don't want to do anything, but from this intellectual property, you can license it, you can even take as sell your intellectual property and do your business. Take the money from them, again, innovations part. Then, if you do have your intellectual property, they do have a certain values. All of us here that Google paid $3.5 billion to purchase a patent portfolio of Motorola. Why? Because they think that entire technology which we are going to take over is intangible assets, isn't intellectual property. They have not purchased the hardware devices because they know that this can be easily formed. But I need a technology. So that is why this intellectual property is having some value. You can easily license it because you are not going to work it. You have your own set of concepts on which you are working. But the research part on the similar domains, you have done a wonderful research. So you just wanted to license it to industry where you think your solution, your technology can useful for them. So you can license it and earn the royalties. A wonderful example, sometimes not really for the license, but yes, for others IPR. Whenever we already have this example, Micromax versus Ericsson. A wonderful example. Micromax has settled a wonderful business infra, selling a mobile at a very lower cost, but they have not done any due diligence on their intellectual property part. Once they have done a business successfully, grow at a level, then Ericsson comes into picture and say that you are infringing our intellectual property. You have not secured your intellectual property, that's okay. But you are not respecting my intellectual property as well. They sued them. And after a battle of 5 years, Delhi High Court award every mobile handset which they are going to manufacture or sell, they have to pay the royalty to Ericsson. So if you are not going to protect your property and you are going to start a business, then you have to carefully respect others' intellectual property. Vice versa, same way, if you do have your intellectual property, you can expect the same and having the same kind of moral rights that I do have certain value, which you have to recognize or mention on your products as well. Then if you do have this intellectual property with you, you do have a power to enforce it. You can send the legal notice to the companies, whosoever is using your property. So whenever we talk about the benefits is n number of benefits from this IP. If you wish to start your business, yes, you do have your lots in having this element of IP in your startup journey. Last but not the least, filing. Yes, you get some kind of paper or certificate where you can just say that this is my intellectual property. So you have to showcase it on your website when you are going to do a business, or maybe mention in your CV, attach those certificates that this is the intellectual property which I get. So these are the credibility which you can earn from this intellectual. Now I'm going to cover, whenever we talk about this intellectual property, there are important key stakeholders in this ecosystem. Students, universities, MSMEs, who is contributing in this economic. So there are good benefits for the universities, professors, students. What are those benefits are? I'm going to start it with the startups, because I think we all heard about this startup and we wish to start something on their own. So if we do have intellectual property, or by the way of intellectual property, we can safeguard our uniqueness of concept. Because I thought that this is a new innovation, which I have done. I filed a patent. Now I'm going to take the leverage or advantage or the benefit which investor is going to recognize. 35% higher possibilities of success than others. Absolutely. When as an investor, I have invested in a couple of startups. Why? I think that there is some kind of business opportunities at a larger level, and they do have their stakes. They do have their own assets, which they can seriously pursue. Higher possibilities of funding, absolutely. If we do have a similar kind of ideas amongst us, and we know that somebody is having a patent file on this similar technology, I think you are also going to choose that the person is having a more credibility. Then monopoly in the market, absolutely. That the patent rights are having a value or time duration of 20 years. You have to innovate regularly, quarterly, wherever you think that you are going to contribute. But you do have your own monopoly when you enter into this market. Easy global expansion. How? If I just wanted to do a business in Korea, and I think innovation is really important for that country. And I have seen the market is there in Korea, in China, in Japan. But there is a language barrier, language constraint for me, and the cost of commutation to start a business in those countries. I filed a patent application in India. On the basis of that patent application, I filed it in Korea, in the Korean translation. It will easy for me if I get a granted certificate from the Korean patent office to identify a local person for doing my business. Because they respect a lot on this intellectual property, IP, and they understand. Then you are going to sell or license your patent to that local partner on which they are going to do the business. So this is some benefits for a startup. If university do have a patents, they can earn huge revenue from commercialization. Identify the problems in the nearby, solve or develop a solution in your campus, file the patents application, go back to those industries and say that we do have a solutions ready. Do you want? If they say yes, definitely. So this is a solution. Yes, you can pay me. But if they are going to try to steal that and they are not going to purchase it from you, then you are going to use the enforceability of your IP. So university get good revenue. Enhanced reputation, higher intake of students, absolutely there. I think lots of advertisement came on our TV channels nowadays that we do have filed a 5,000 patent applications, which ties students to take the admission in that university where the practical approach would be. And I'm more credible. That is why university can have the enhanced reputation. NAC accreditation, yeah, absolutely. That has been the added advantage. If you do file a good number of patent application by university, then they get a good NAC accreditation. If IP is being there, then it is very easy for universities to collaborate with the foreign universities and try to make a curriculum which is really important for nowadays. And the student can go do the 6 months of the studies here, and then the rest of the studies can do in the different universities. So collaboration is also important by the way of intellectual property. Then it increases the industry academia relationship. If you solve a problem, industry people by universities, student, faculty, guides, then I think they are going to hire. If I'm talking about in terms of important key stakeholder as a student, then a student do have a lots of opportunities if they file the patent applications or intellectual property. Get admission in top universities. We do have an examples with us where a student filed a patent application and they get a 70% of a scholarship in their fees. Ahead of others in job interview, absolutely. A big giants or the big companies are looking for those candidates who has filed a patent application because they developed the idea or the technology. Revenue generation from monetization, absolutely. They don't wish to work on the similar kind of method. They just apply it. They have thought of a very good technology, filed a patent application, don't want to do a business, just give it to others to use it and pay you some kind of compensation or the value. A spin off from college to be a business owner. Nowadays, a very good platform for the students from incubation centers, and everybody wants to do. And this startup becoming alternative career options as well. But this intellectual property is a key element in their success. If nothing has been done, then this intellectual property is safeguard so that they can enter into more interviews. Similar kind of benefits for entrepreneurs, the business growth absolutely be there. We do have one example with our startup ecosystem where the person have the three founders started a business and they are struggling with this cash, and they asked us to file the patent application at a very lower cost. And we did that. We have drafted a patent application because we just wanted to support the entrepreneurs. We are not going to create a barrier for them. After they filed one application, they got a very good investor on board. And once that journey has been started, after 6 months or 1 year down the line, now they are filing good number of applications every month. Because this IP gives them a potential collaboration opportunities. Credibility of a brand absolutely been there. If you can just go on the Whiteboard database, there are big giants, Microsoft, Google, Apple, they have filed n number of patent application in a month. They just wanted to, because they thought that the research which they have done is really important, and having certain values which they are going to earn once it has been monetized in terms of selling the technologies, doing some kind of license arrangements, or if anybody is going to use it free, then they are going to send some legal notices. So it's really important. Franchisee possibilities, wonderful trademark, a coined mark, and getting a huge traction. The app which you have been developed, a good downloads by consumers end. Then I think everybody is looking for some kind of possibilities to join hands together. Very easy if you do have your IP. If you don't have your trademark registered, then they are going to use it free and use again start a shop on your name. Competitive edge, the first mover advantage absolutely being there. So whenever we talk about this intellectual property, it acts as a tool, business tool, not as an obligation that you should file the patent application. You should file the IP. If you file or publish it in a journals, really use without having values. Values in a limited constraint, yes, you do have some values, but in the monetization compensation, there's nothing values. And if something came up as a product on your building on your research, then you are not going to claim it. So we have to carefully analyze at a very initial stage, because intellectual property office didn't require some kind of prototype from your end. They required your thoughts on a paper, the idea, the process, the flow, the functionality which you are going to cover, the technology which you think that is very innovative and you have developed. So there are lots of process. When we filed a patent application, we have to perform a prior art search. If we just wanted to invalidate, we find out that somebody is taking extra advantage, then we are going to do the invalidity search to invalidate their claim sets. But this intellectual property getting a huge traction nowadays in this startup ecosystem, in professors' life, in universities' perspective. That is why it has been filed a good number of patent applications, but less than the comparison with the other countries. Now, this is the example of commercialization, because every time somebody asks me that we filed a patent application, we get a patent application, how exactly we are going to commercialize? The real importance of a patent application is being written in the form of claims. If you have right set of claims written and properly formatted, then you are easy to enforce it on the person who is going to replicate the same thing. This is the example when inventor, this ring pool, everybody knows. That lady filed a patent application on the same, and Coca-Cola take it from her, and they are giving 148,000 UK pounds a day on royalties. So it's really important, once you think that your concept, your research is really disruptive and innovative, is new in the market, then you should go ahead. And then you're getting a higher chances to commercialize it. Otherwise, you're a paper which you can file it and getting an application number. Whenever I talk with those people, they say that somebody's filed the patent application at 5,000 rupees. I'm saying the quality of a claim set which is going to be draft is really important for you. You are going to regret after 4 years that the concept is really new, but it has not been properly crafted on a paper and submitted as a patent application. Now, another example. We all heard about these brand names: Nike, Adidas, Reebok, Levi's. They do have a trademarks. They don't have physical factories. They are earning a huge profit or revenue on building these brands. So from this brand names, they earn a huge revenue. So it's really important to file and secure under the intellectual property rights. Now, I'm coming back to the first thing which I said, that everything is not covered under this intellectual property, or everything is not patentable. So what should we do? That the concept or the recipes or the secret sauces, how exactly we are going to protect? You can protect by the way of trade secrets. The formula of Coca-Cola, if they are going to file the patent application, it has been going to be published after 18 months. Then everybody knows that how to make a Coca-Cola. So the assets which you do have, the skill sets which you do have, properly analyze that either it should come under hands, I can file it. If I'm not going to file it in the patent application, I can secure it in the copy, or there's no IP on my product or on my service. Then this thought comes to us. We have developed this process: ideation, validation, evaluation, powered by patent. We identified a wonderful problem. I'm just showcasing it to you. The speakers have to adjust the microphone height and distance issue, which they are going every time when they are going on a dais. Then they don't know the previous person is having some kind of contagious disease or not. Might be there because in this, even when we see this COVID guidelines, we have to maintain some kind of distance. We are not going to touch any objects just to safeguard ourselves from these viruses. We have identified this problem that every time we speak to adjust from their height. We find the solution. Like if we are going to make or use some kind of sensors in the same, then it is going to be work. Whenever a speaker is going to there, a microphone is automatically adjusted. They file up immediately a patent application. They have not developed any kind of prototype at that time. It has been our mind. The solution is in by our mind, and we have put it on a paper, filed a patent application. Even we have filed a PCT application as well. Then we hired a startup or a company just to make or develop a prototype. We had a unique tech designs from a Jubilee incubation center, and which they are being ready with the prototype. Stuck in between, but yes, it has been working. So it's really important when we have to evaluate our startups, we evaluate our concept, our ideas, our solutions. Not necessarily required a prototype, but yes, if you are going to work on the product side, technology side, then you have to put it on paper as a blueprint, draft creation, file it in the patent office. Now, this is the definition of a trademark, because I'm going to cover the whole aspects of this intellectual property. Trademark means a mark capable of being represented graphically and which is capable of distinguishing of the goods or service of one person from those of others, and may include the shape of goods, their packaging, combination of colors. You can file your brand name just to take some kind of brand identity. There are a number of brand names. Even one company can file a different brand names. They are going to create some kind of image in consumers' mind. Everybody is not going to ask HUL they do. They are going to ask a specific product. Might be the name of a Colgate, any product related to that company. They are not going to recognize the product as a Palmolive, P&L. We require a product. A toothpaste from P&L. No. They're just going to ask with a specific trade name. So it's really important to understand the importance of this intellectual property. The advantages of a trademark: build trust and understanding. Trust because when you go out, you have some option to purchase in apparel industry, and might be the quality is also enhanced, but you just go with the brand names. We are and even we pay the higher prices because we think that the brand is having some trust that has been gained by their popularity, by their credibility, by their brand identity. Exclusive right, absolutely. Nobody is going to copy. If they are going to copy, definitely there is a provision to claim the damages. And nowadays, laws has been little bit stringent. So it's really important to protect your trademark applications as well. Differentiating the products and services, absolutely been there. Symbols, when you applied for a trademark application, you can use TM on the top of your application. When you get a registered certificate from the trademark registry, you can put R under the circle. Few examples, this logos which has been uniquely designed and very popular in the market: Maggi, McDonald's, Nike, Apple's brand name, Coca-Cola. We talked about the copyright. These are some important part which has been covered under the copyright. Literary work, a wonderful literature which you have written in the form of books, magazines, novels, you can protect under that literary works. You think that you have designed a wonderful cartoon characters, but how exactly you are going to protect those cartoon characters? And that is sick form in copyright. The students had been done a wonderful theater drama, but they just wanted to because somebody had clips of same and they are going to replicate. They have to protect under the copyright. Musical notes absolutely covered under the copyright. These are some advantages. I think we all heard about the Three Idiots movie, and the novel which has been written by Chetan Bhagat. So he only demands that the thing, this is my moral right, which I have written, give some recognition to me. That has been given by movie after so long. Then advantage, right to produce the thing on which you are owner, you are having a right to produce it, right to authorize it to anybody else in the form of license, assignment license. You pay somebody. Then if you file your copyright, you get a protection. Symbol of copyright, C under the circle. For example, sometimes there is a huge conflict or a myth that computer softwares or an algorithm, as per Indian Patentable Act, that computer software programs are not patentable subject matter. So there is a provision under the copyright where you can protect these computer softwares, Microsoft Windows, Linux, and even the web browsers, word processors. You can protect under the copyright regime. The geographical indication, we already talked a lot, so I'm just skipping off the definitions. You heard about the Basmati rice, Darjeeling tea, Kangra tea, Feni, Alfonso mango. So these are all the geographical indications which has been covered, and from that they knows the territory itself. Even the Rasgulla, when we talk about, and you know that the large battle has been happened. Who gets this Rasgulla? So there are good sets of geographical indications filed by states that the commodity, the products has been filed for the taking a protection on their geographical commodities. Boost tourism, boost export and economic growth. Absolutely been there. If I'm going to purchase a Pashmina shawl, I have to pay the higher prices, which increase the growth of that territory as well. If I have to go to Kashmir, then it's because of Pashmina that I have come here just to see that geographical indication, how exactly that has been built. Tourism is boost. Export, because more countries are relied and they think that you are the sole originator of that commodity. And you get the credibility or having a GI tag of that in that commodity. So export is boosted. Symbols, that is a GI tag itself. Now the third, design part. Design, overall aesthetic looks of the product is being protected. Product is good. The functionality is covered under the patent. But when we talk about the looks of the product, the design of the product, it should go with the design. It should be novel, original, absolutely. Novelty being required by filing a patent applications even well. It should be applicable to a functional article, no worries at all. It should be visible on a finished article, it should require. There should be no prior publication or disclosure of the design. The similar being like, if we get some kind of objections from the patent office, some similar kind of process has been applicable in the design as well. Advantage of design, generation of revenue, provision of exclusive rights on the specific design, facilitation from marketing and commercialization, because you are going to protect design of your products. Few examples, these are cycle, designs of the bottles, it has been going to cover under the design registration. Now I talked a little bit on this trade secret. Now I'm going to cover in depth. A trade secret is an information that has value by virtue of not being generally known. The formulas, the process, which I have to keep by myself, a Maggi masala. But I'm not going to file as a patent. I'm not going, because there is no provision to file as a design on this Maggi masala. There's no design associated. Copyright, no, there is nothing to protect this formula in the copyright formation. So I have to keep it as a trade secret. The information has value to others who cannot legitimately obtain the information. The information is subject to reasonable efforts to maintain secrecy. When we talk about the Coca-Cola formula, even they have protected under the vault of Atlanta. They have protected that formulation. Signed lot agreements between their co-founders, management, top hierarchy, whosoever knows this formula, they are having a liability clause which they are going to mention in their trade secrets agreements. Definition is a formula, pattern, physical device, idea, process, technical information that is used in manufacturing procedure, compilation of information which is generally not known, relevant business circles or to public confers some sort of economic benefits on its own. So anything which you think if knows about the other people, they can use it and they can manufacture it and you can't stop them. You can just keep them as a secret sauce, secret recipes, closed in a box. That's it. We have taken the example of Coca-Cola, KFC kitchen recipe, masalas, they have already been protected under the trade secrets. Types already been told you, formula, design, automation, process. Formula for a product, some types of products such as foods are required to display ingredients on the label in most jurisdictions. However, this is usually a high level list of ingredients that leaves the exact formula as a secret. They mention the ingredients on that specific product box, but they are not going to disclose the exact formula, how they have built that. A process such as coding process that result in an advertisement such as unique flavor, they are going to protect under the trade secrets. This is not the intellectual property rights protection, but yes, it is your intellectual asset which you have to keep with yourself by signing a contract, agreement, assignments. You can do that part. Proprietary system or robotics that automated work to efficiency and quality, yes, absolutely being there. The design of a product or service, it can be difficult to keep design secrets for long as they can be typically reverse engineered. Examples we have already taken. If there is advantage, then there would be one disadvantage as well. The best known example, trade secret, Coca-Cola, it has used trade secrets to keep its formula from becoming public over a period of decades. So they have secured. The company never applied for patent. It was never required to disclose the formula. One disadvantage is that they do not provide any legal security against an independent competitor inventing an ethical object. If you have protected under the trade secret, somebody else is developing the similar kind of thing, not by stealing your formula, but they develop by doing regular research or analysis. They have developed the similar process, then you can't sue them. There is no legal security. So this is a disadvantage when you have your trade secrets. How to guard? Restricting number of people having access to secret information, signing confidentially. Wherever you are going to disclose your idea or the patents, you can sign the non-disclosure agreement, the confidentiality agreement. Even before doing the prior research, you can sign non-disclosure agreement with your patent attorneys or the patent experts. Using protective techniques like digital data security tools, restricting entry into areas where trade secrets. National legislation provide protection in form of injunction damages if any secret information is illegally acquired or used. If somebody has been steal your trade secrets and employee done that part, then there is a contract clause which has been signed at the time of employment. That this is the secret recipe which we are going to disclose, or maybe you are going to identify by working in the similar processing. So you have to carefully that you have to keep this secret with you, not going to disclose in any other company or to any competitor. Otherwise, you have to bear the consequences and pay the liabilities. So this is how you are going to protect your trade secrets apart from all your intellectual property, intellectual assets. Now, this is a conclusion of my presentation on this intellectual property act as a catalyst for a business tool. If you do have any questions related to the patent, trademarks, copyright, design, or anything you wish to ask, I'm opening this platform for whole audiences, how you are going to commercialize your patent or other things. I'm happy to answer this. So thanks a lot. Here I'm going to end it. So thanks all audience to hear it patiently. And if any questions, happy to answer them as well.
Thank you, sir. Though I am not the presenter today, but I am luckily part of the panel. So, with the permission from Ashok sir and
Yes,
Orpita,
yes.
can I ask a question?
Yes, madam. You can
Actually,
ask.
I'm having problems typing in the question answer box. So, if I am allowed, thank you
Okay.
very much, sir. A very, very well designed presentation, and particularly for, for novices. You see, we are not of that area, so making it very, very clear and crisp and simple for us to understand, taking examples that we see in daily life was absolutely brilliant. Sir, I have two questions. One
Sure.
question is, sir, that um, when we are talking about the copyright, but the copyright issue is very, very contentious, primarily because of digital platforms. You see, there is this occasion where the co-founder of Facebook asks the Napster that what you did is very wrong, and the Napster says that, well, keep that aside. When was the last time you went and bought a CD? So the thing is that whether we have litigations or not, they can be embroiled for a very long time, and in the process that creation suffers. So something on that, sir, something which we can do to protect that. One. And second is, sir, when you're talking about the students, the benefits of patents to students, you were talking about they getting better opportunities for jobs. That is absolutely excellent. But what if there is some misuse by employers? It does happen, sir. We have heard about such cases. So if there is some suggestions that you can provide students, that they can save themselves from that kind of a problem. That's all, sir.
Sure, Momitati. Thank you. Thanks a lot for asking these questions. And this is really important to understand how, because this copyright resign. As per the Berne Convention Treaty, when we talk about this copyright, the first person who is going to publish anything in the domain, that is the owner of that property. Okay, this is the one thing. As per the Berne Convention Treaty, they don't require to file again a copyright application for the same. But yes, it is very difficult to prove that this is my claimed application, this is my innovation, this is my creativity. That is why they are going to file a copyright application. Now, the thing when we talk about this internet piracy and other things, when they are going to copy it, the one movie which has been recently come, Radhe, and that has been freely available on internet platforms by stealing. So even they have approached the cyber cell to stop the piracy of their cinematograph rights, because they have done huge efforts to make the entire movie. So they just wanted to get some kind of permission. Even before that, there's a one instance, I think everybody aware, where a DJ owners should stop playing the songs which have not been getting the permissions from the singers. So that has been done in the past, but after a certain period or certain period of mutual understanding between them, or some kind of arrangements they have done, and it has been allowed. So only demerit of this copyright application, that it is really hard to prove in the courts of law that I am the creator. That is why you have to take or obtain the certificate for your originality or creativity, just to prove that this is my creativity. This is the one part. Then it has been permissible in the court of law that somebody is going to copy without my permissions. I am going to give them the assignment or a license or any particular format which has been allowed by the law. I'm happily going to give it. If the if the author is not available or the owner of that creation is not available, then it has been given as a compulsory license. Okay, that somebody has done something, but the author is not there or it has not been traceable, then the compulsory license should be issued. Okay, so only thing is that this is a demerit, but yes, you have to carefully identify either you should go ahead and protect under the copyright applications or not. Otherwise, it's a lengthy process or cost cumbersome process if you are going to litigate it, prove it, my copyright creation. Okay, so this is on the first part. Second, when we talk about the students part, if they filed a patent application, so they have to carefully what you can say, probably decide who is the IP contributor amongst us. Okay, means if there is a guide involved, if there is a university involved, because sometimes at the type of engagement which they are going to do in the employer's premises, if they do anything related to the research or developing a concept, then the IP belongs to the employer. This is some kind of which they are going to written in the contracts at the time of employment, that the IP belongs to the employer. If you are doing any kind of research, if you are going to file any patent application, that has been going to the employment. So it has been carefully read the terms and conditions by the student who is going to opt for the employment opportunity. Otherwise, even with this, sometimes some ad developers, they are going to use the open source codes, but they didn't read all the terms and conditions. Might be there's a clause mentioned that if you are going to use this source code for the purpose of commercialization, or you are going to earn some kind of money, you have to pay us. So sometimes we missed on, but we realize once they are going to file some suits on us. So this is the responsibility or a proper due diligence is required from a student side by signing the employment agreements for the company. Otherwise, it has been going to be conflict again, and they are going to steal, and they are claiming that this is our intellectual property as per the contract. Because in India, this is permissible in the court of law. The agreements and the contract which has been signed at the time of employment. This has been the case with the even with the universities. If you have done any kind of research or something used by in the labs of the universities, and you are going to file a patent application, you can take some permissions. If university is going to pay the amount because the patent fee is on the higher side, if you are going to apply applicant as a university. So if university is ready to pay all the fees, you can do some kind of contract that the royalties, the fee which we are going to earn from this patent application, we can share in the format of 80-20, 50-50, whatsoever. Okay, so this can be possible, but this has to be carefully done a due diligence by a student when he is going to take the employment offer.
Thank you very much, sir. Thank you for the clarification.
Thank you, Mom.
Okay, any other questions?
So, any other questions from
participant? Any other question from participant? Okay, there is no other question.
If any question is unanswered, or you think that something came up later on when you realize that you should open a venture or not, you should file a patent application or not, I'm happily available on different platforms, on LinkedIn, on Twitter, on Insta. So you can reach me to helping on this intellectual property prospect. I'm not going to take a consultancy fee, so don't worry. But yes, absolutely, I'm helping you. Once you grow enough, or you can become some kind of unicorn by using your innovation, I think my value comes into picture. So that is my commitment or Boudhik Ventures motive to give them those opportunities, not as an obstacles.
Okay, thank you very much. Thank you very much, Mr. Saurabh Tiwari. It was really interesting, and the way you have explained that it was very nice, and we could understand the things, especially the examples what you have shown in that ring pool cans, that so much of money has been earned from the simple idea. So many times we are having ideas, so it is better to use it, better to file some idea and keep, instead of keeping the idea within ourselves, better to disclose that idea, and there may be some commercial benefit. So with that hope, we should disclose the idea. It was very interesting, and actually I was very much impressed with the automatic adjustment of the microphone, and that automatic adjustment of the microphone, that without touching, the microphone will be aligned itself. So that is really a high level of automation. And I understand that people have already done the patent on this. As you told that, okay, that Indian patent number that people have already patented. So in this
No, we have filed, Mr. Paul, we have filed the patent applications.
Okay, you have filed. Okay.
Yeah.
Okay, so that means, in this critical situation, wherever there is an opportunity, we should try to file. We should try to file, and that whatever is the innovation, we should try to file. And that is that your talk is very much encouraging to us. So thank you very much. Okay, we hope, okay, we will consult you, we may consult you for some, if there is any difficulty, or if we feel that, okay, that we can consult you by your email or by your LinkedIn address. So thank you.
Absolutely, sir. Thanks a lot. Thanks a lot for giving me this wonderful opportunity. All the teachers, all the faculties has been there. They are our gurus. And now only thing is that I am specific or perfect in one aspect in intellectual property rights. So it's my pleasure to being in front of all of the faculties or the university. So thanks a lot once again.
Okay. Thank you, Mr. Saurabh. Okay, dear participant and the panelists. See, now our next speaker is Dr. Shambhu Prasad Chakraborty. Our next speaker is Dr. Shambhu Prasad Chakraborty. He is head and research fellow at Center for Regulatory Studies, Governance and Public Policy. He is chief editor of NUJS Journal of Regulatory Studies. Now, Dr. Shambhu Prasad Chakraborty is currently the head and research fellow at the Center for Regulatory Studies, Governance and Public Policy, the West Bengal National University of Judicial Science, Kolkata. He is the chief editor of NEJS Journal of Regulatory Studies. His area of research is tribal and indigenous rights, climate change, intellectual property rights, and technology law. He has authored 4 books, 30 articles, and book chapters in Scopus Index and Care Listed Journal, and presented research papers in more than 50 national and international conference, webinars. And he was awarded with gold medal for winning young parliament competition by the government of West Bengal. He topped his school at class 2 level and college in his LLB degree, and topped at the University of Calcutta in his 4th year. He was conferred PhD degree in law from the North Bengal University in 2017. With more than 14 years of teaching and research experience, Dr. Chakraborty is also a member of prestigious Law and Society Association USA and Commonwealth Lawyer Association London. Today, his topic is General Principles of IPR. So with this introduction, I request Dr. Shambhu Prasad Chakraborty to proceed with his speech.
Thank you, Professor Ashok Kumar Paul. I hope I'm audible.
Yes.
Well, it's a privilege to be a part of this particular 5-day, I think, faculty development program. And I really feel privileged to be here and might be sharing a few thoughts on the general principles of intellectual property rights. I think, the majority of the people who are here are faculties of this university?
Yes.
Okay, okay. Okay, so I would like to share a small slide so that it'll be easier for them to follow the things. But before I move on to this sharing, I'd like to know whether you have law faculty members also along with other faculty members.
We do not know actually, sir, that whether we have.
Okay. So what are the various courses that these faculties are teaching right now?
Actually, we are teaching various from engineering discipline. Okay, that electronics, electrical, mechanical, civil, computer science, computer application. We have got pharmacy. Then we are having biotechnology department, physics, chemistry, and we are also having law department, the law and commerce department. But we don't know actually that participant that who are from law.
Okay, okay, great. The reason for this is that I would like to bring in those examples and illustrations perhaps which would be suitable to the faculty members who are working in this particular domain. So here we go with this sharing. I hope.
Yeah, it is visible.
Is it visible? Okay, yeah, great, great. Okay. See, there are three things that I'd like to start with, and since the majority of the people who are listening are belonging to the science and technology background, it's important to understand that intellectual property basically circulates around these three aspects. Now, yeah. Now, the first thing that I'd like everyone to understand is the word intellectual property is comprising of two specific words. One is intellectual and the other one is property. Now, I'll not go deep into intellectuality because all of you are intellectuals in one way or the other. But I'd like to help you to understand broadly what property is. Now, the two words, as I was talking about, is basically the use of intellect on one hand and having a commercial value on the other. These are the two broad aspects that I like to focus when we are talking about the word intellectual. Now, when you're talking about the word property, let us understand that every property, whether it's something which can be perceived through our senses, like that of a tangible property or an intangible property, every property actually have two broad things. One is called the corpus. Corpus means a body without a soul, okay? And the animus is considered to be the soul per se. So that means like human beings, a dead body is basically the corpse. And when the body is with the soul, it is a human being. Just like that, every property possesses these two aspects. One is the animus and the other one is the corpus. Now, why I'm talking about these two aspects is because two broad understanding of law stands on these two aspects. One is called ownership, and number two, the other one is called possession. Now, what exactly is ownership? When you are buying, say, for example, a mobile phone, are you the owner of that particular mobile phone? Well, broadly speaking, yes. Now, just imagine that you have developed a machine, or you might have developed a software in your or a programming or anything while you're working or when you're in your own house out of fun. Don't you think that you are the property of that particular invention of yours? Now, how does the concept of ownership vary from something that you're purchasing from the market and something you are creating? So the concept of ownership also needs a proper retrospection when we are studying intellectual property per se. I'll just go deep into some of the examples, but after a little while. Hang on a second, now, coming back to the use of intellect, like you are spending time, you are spending energy, you are spending your money, you're spending your research, and then you're coming out to a particular outcome. And that particular outcome is something which you think that you are owning, and you are right now possessing the same. Now, how long are you going to possess that? See, at the end of the day, you create those things so that it can be used by common people like us who have not invented that. And you cannot but give that particular work of yours to another organization who is basically, okay, in a position.
So sorry to interrupt you. If you please zoom your slide presentation.
Okay. Is it fine?
No, sir. Actually, if at all you get into a slide presentation mode, like where you the slides numbers that is there shouldn't be shown like.
Slides. Okay, if possible, you can.
Yeah, exactly. This is, I suppose. Slide view. Sir, that one, I suppose. You just click it.
Is it good right now?
Yeah. Yes.
Okay. Just hang on.
Okay.
I'm trying to do that actually. Like, I have a couple of screens together working here, so might be.
Oh, okay, sir. You continue.
Okay, sir. Okay, you can continue.
You continue, sir.
Okay. So coming down to the broader understanding of inventing something, working on it, and not really like in a position to market it. Now, this is something which is common to a lot of people. There are many people who come down to us and say that, like, I want to explore this. You please give somebody by which, like, I can take this work of mine to the common people, to the people at large. Now, as I was talking about, like, we need an intermediary who have that particular infrastructure. Now, if it is, say, for example, a medicine, we need a manufacturer of that particular medicine. We need a lot of, like, legal aspects, whether it has been tested, whether it is good, whether it turns out to be bad. There's so many things that comes up. If that is a software, maybe, like, you need a proper platform who tests those things and then take this particular invention of yours and then use it. Now, the question is, do you require some sort of a protection that you are the exclusive owner of that particular invention? Now, this is a very interesting dilemma. Like, you have spent time, you have given a lot of time, and suddenly, like, after getting a few thousand rupees, the thing is transferred to somebody else. Now, that particular somebody else becomes the owner of that particular property. See, this is exactly the reason why I want you people to understand the relationship between intellectual property and common property per se. Because in case of a common property, it has some sort of a tangible experience that you can have. Like say, for example, the hard copy books today that we have. And because of the pandemic, we don't have even published copies. We only have soft copies of the books. So we cannot touch, we can print a copy of that per se. But basically, there's a huge difference between what it used to be and what it is happening right now. So your book, your paper, you won't be able to give it to somebody else just because you have signed an agreement where you have transferred your right on that particular work, even when you have spent nights, you have spent hours, you have worked on it, and it's gone. So, and even like in a very recent experience of mine, like Brill is one of the most famous publishers in the world, especially in the UK. They have come up with one plan, and that is like even when they're sharing that soft version of that chapter that I have contributed, for the authors to contribute, they can only take 25 printouts of that particular document. Just imagine. That means I can distribute my work and I can print out my work only to an extent of 25. So this is something which at times seems to be immoral, and sometimes like it needs retrospection. So this is where I come down to one of a very interesting case law. Now, this particular case is a very famous case, and this happened in the backdrop of the United States of America. Now, this case is exactly when a VCR was manufactured. Now, what is a VCR? A VCR stands for, I think everyone knows here, a video cassette recorder. And when it came up during the 1980s, it was not very cheap. It was pretty expensive. I can remember one of my friends in the locality whose father works in the Merchant Navy got one, and when we asked about it, like it was very expensive recorder. Now, what was it doing? Before I say about where the infringement lie, I would like everyone to think, okay, that suppose there is a broadcasting and there is a content, and that particular content is created, might be a movie or something. Let's take an example of a movie. And now that particular movie is transmitted through a particular media. And that is a license has been taken by a particular TV channel to show that particular program, and the viewers can watch. And that is exactly how the things go on. And before those that particular movie is transferred to the broadcasting system, it is divided, say for example, into a few number of slots. Like after 15 minutes, there are some advertisement coming in, and then in this way, this particular thing comes up, and then it goes to the media house when it transmits. Now, what does a video cassette recorder do at that time? And that was that manufacturer was Sony, and this actually posed two major problems. The first problem was that any person who is recording the entire movie with that particular tape would very easily fast forward and omit that advertisement part. Now, what is that advertisement part? See, let me tell you, when we watch the advertisements, it somehow or the other stay in our mind, and we tend to buy those products during our day-to-day life. It'll be more easier for us to take an example of a young kid who looks into those advertisements. So, for example, when your children tells you that I want to buy a toothpaste, he would say that I like to go for Colgate, because every day that advertisement comes up, and that's exactly what makes it famous. And once we buy that particular paste, and that's not only me but everybody, then the sharing, like the money that the advertisers are giving to that particular TV channel, they're getting back from the market, and that's exactly how the thing works. Now, if this particular recorder intercepts this particular process, then the advertisers would lose their revenue. And that is exactly where the suit lies. That is number one. And number two is that whether they are using it for commercial purposes. These are the two broad questions that came up in this particular case. And this matter goes to the lower court, and the lower court say that there is no harm in recording programs. It's completely non-commercial because you're back home and you're watching it at any point of time, and it's just perfectly fine. The matter goes to the appellate court, and the appellate court goes against Sony and tells that there are enough issues in this particular matter. And there are so many video cassette parlors who are renting out these cassettes, and there is a lot of loss that can apparently be seen. The matter goes to the Supreme Court, and the Supreme Court, there are 9 judges, I can still remember, in that Supreme Court case during the 1990s. This was heard by the US Supreme Court. And the judges were divided into 5:4. The 5-judge bench actually said that what Sony was doing was not illegal, because we cannot per se say that every household people are doing it for commercial purposes and everyone is selling it or renting it out to people. And it is the responsibility of the state that if a particular video cassette parlor rents out a cassette which violates the copyright laws of the land, then action will be taken against him and not the recording machine. Recording machine can be used for many other purposes. It has many fair value. So just because it can do something which might affect the advertisers would not be the sole cause for stopping or filing a litigation, going a litigation in favor of the media and against the corporation, Sony Corporation. So this is a very interesting case. In a recent scenario, another particular case came up in India, and the same thing happened, and it was the hard disk era, if I may be allowed to say so, where you have the CD-ROM, CD writer, DVD writer. That is the era. And a litigation came up whereby a few people were arrested because they were copying things and selling it in the market on certain disks. In defense to this particular person, the advocate came up with a very typical defense, and he said that, my lord, look at the fallacy of the system. And he stated that if you look at all the things that were taken away from that particular place where this was happening, you'll find that the laptop that was used for copying was made by Sony. So they have an inbuilt Sony DVD writer. They have been using Sony blank DVDs, so they've paid it to Sony, and they were copying a movie called The Spider-Man, and The Spider-Man is again a Sony production. And the advocate said that Sony has filed a litigation against these people, and the complaint was because their movies are being pirated, their DVDs are not being sold in the market. Now, those people who are infringing this particular thing has been paying to Sony. When they bought this DVD, they paid it to Sony. When they bought this DVD writer, they paid it to Sony. When they bought this laptop, they paid it to Sony. And now Sony is filing a litigation that you can't do it against in this particular manner because that's infringing our rights. So intellectual property, per se, is a very interesting area of deliberation. Now, why this is becoming more complicated day by day is because at one point of time, knowledge was meant to be free. It was meant to be distributed for free. And what was the quid pro quo? Quid pro quo meant something in return. What was the return that these people were getting is respect in the market, respect from the society. Perhaps maybe they have been provided with medals, with titles. But what is happening today? I'll just give a couple of examples. Somebody reported to me that his LLM dissertation, his master degree dissertation, which was very, very good and acknowledged by the university has been like, you know, a lot of small things have been taken over from that particular dissertation by his own supervisor in the book that he has published. Now, the question arises that whether there is a moral obligation on the part of the supervisor to acknowledge the author, or at least got some sort of a permission from this particular author, because that young guy was his own student. Now, this is something I think, you know, all of us must have seen in practice and in vogue in almost all areas, not only in law, but in all areas. So this is something which I would like to highlight again. Now, coming back to the introductory slide that I raised out, and that's exactly where this intellectual property comes up, is because of the development of science and technology. You people in the last 70, 80 years have made copying, same with the Sonic cases that I discussed, so easy that it becomes literally impossible to identify who is the actual creator of that. There are so memes, you know, that we see on Facebook, that we get on our WhatsApp every day. Sometimes they're very attractive, sometimes they're not. But at the end of the day, they all are brilliantly, you know, crafted. Whether they're telling the right story or a false story is something which is different. But what I'm trying to make everybody understand here is that nobody would be able to know who actually have created and transferred it. Now, this is exactly like, you know, the challenge that we are in, the science and technology challenge. And perhaps, you know, some of you people, I'm sure, would be able to understand that this is the reason why we are trying to invoke blockchain technology 4.0 in our country. Maybe at this juncture, we are planning to implement it in the healthcare sector, might be in the smart city movement, so that, like, you know, everything becomes transparent, and you can easily go back to the pages of the past. You can look exactly who uploaded this in the first instance, and that goes on and on and on. And the same thing is happening with the Information Technology Act being amended, and the minimum number of years that every content needs to be kept by the service providers and the intermediaries has rose up to 10 years. So all these things are something which is very interesting, and it's coming up every now and then. So the importance of the time, devotion, talent, money, everything that's been given by the particular person who created that particular software, created that particular poem, created that particular craft, that architecture, needs to be acknowledged. And now the onus has shifted as we are progressing with time. It has shifted from the state, as I stated a little earlier, that previously the king used to give them titles. So the state, the king, the country, who used to give medals, give honors, awards, that has shifted to individual persons who are creating those creations. And that is exactly what has led to a charter which is known as the Havana Charter. This came up in the year 948. A lot of people do not know about it, because in this particular charter, you know, for the very first time, we can see that the entire concept of assets, in other words, properties, have been divided into two broad categories. One was economic assets, and the other one, non-economic assets. I'll talk more about non-economic assets a little later with a couple of examples. But let's first talk about the economic assets. Economic assets means the assets, the exploitation of which would bring in more revenue, would boost up the the common people would be living a more comfortable life. And that is exactly what led to the formation of the World Trade Organization, or WTO. And this WTO has come up with a separate wing to deal with industrial property. Because let me tell you, like, prior to coming of this particular term, intellectual property, these properties, which were intangible in nature, which you cannot perceive through our senses, like touch, we can't touch something which is called a patent or a trademark, we can't do that. But for them, the name at that particular time, before the word intellectual property came up, was industrial property. And which is basically like, you know, the WTO, World Trade Organization, was talking about. And it created a wing which is known as the World Intellectual Property Organization. Now, this World Intellectual Property Organization is something, you know, which is in charge of creating and developing the various intellectual properties. And they are the organization who carried on the journey for the last 20-25 years and have made all the regulations for patent, trademark, and different other intellectual properties. But at this juncture, I'd like to tell you that we are missing out on non-economic assets. Now, non-economic assets, in this Havana Charter, it was proposed that there would be something like that of WTO, or World Trade Organization, which actually never came up. And this particular non-economic, you know, asset is something which got ignored. And why I'm talking about this ignorance, I think, you know, it's perhaps because I want to identify that the economic exploitation of the bioresources and the genetic resources of the third world countries like that of ours were the main reasons. And that's exactly why even this Havana Charter was not accepted by the US at that particular time, 1948. Well, I'll talk more about the non-economic asset and how we have failed to protect it and how we can protect it in the years to come. I spoke about this. Yeah, I spoke about tangible and intangible property to my friends. Yes, I spoke about intellectual property, which was previously known as industrial property. Now, yes, types of patent. It's important for all of us to know these basic types. There are some more. I will not explore other aspects. I'll start with patent because, you know, you people are more into patent than into other aspects. I would say, like, you know, I'll just give a small example, you know, with the aid of which you'll be able to understand all the intellectual properties at one go. Imagine a Coca-Cola bottle, okay? Imagine a glass Coca-Cola bottle. Look at the shape of that particular bottle, okay? That particular shape, that particular design is protected by the design law of intellectual property, okay? That's there on the screen right now. Now, the particular mark, Coca-Cola, just imagine the Coca-Cola mark. That is something which others cannot copy. And that is exactly the trademark, which is there again on the screen at point number 3. Now, the particular drink that I'm talking about, the Coca-Cola by itself, that particular drink is created by composition of a few things. Maybe some chemicals, maybe something else, preservatives, etc., etc. And that is exactly which is the subject matter of patent. But remember, at this point, let me tell you that it is very important for the applicant to understand that patent is always limited to 20 years. So that means if you take a patent, you will be having the monopoly of that particular thing for a span of only 20 years. And then anybody can explore and exploit that. So that means if I create a medicine per se, say for example, medicine which will cure a coronavirus at one go, and I take a patent of it, that patent will last for a period of 20 years. And after that, anybody else can do it. Okay, I won't be having a monopoly on that particular formula in any ways. Now, would Coca-Cola give this particular concept of its, the chemical composition of that particular drink to each and anybody? The answer is no. They want a perpetual protection of that particular thing. And that is exactly why we have something called trade secrets. So if you recognize or if you register that particular drink or that composition by this trade secret intellectual property protection, then this 20-year capping would not be imposed on you. Okay. Now, I don't know how many of you people have visited US or UK or other countries. In my experience, a Coca-Cola tastes differently. When I drank a Coca-Cola bottle in US and when I drink it and I compare that when it comes to India, there is a difference in taste. I'm not saying that the taste of Coca-Cola when I had it in the US was so good that I fell down. It's not something like that. But the only reason why I'm comparing is to make you people understand that they're different. And I'm sure you people have got these type of comments, you've heard these type of things on many occasions. So this particular formula might vary from one place to the other. So all these things, are within the purview of trade secrets. But one thing is important. When you buy say for example, you bought a plastic bottle or something like that of a cold drink, you'll find that it's written made in India. Yeah. If you buy it in Singapore, it's written made in Singapore. Malaysia, it's made in Malaysia. So that is exactly the location, which is called the geographical indication of that particular product. Okay. And nowadays it has become so common that people are trying to, use that more often than before. Like a Sony TV made in China and a Sony TV made in Japan, I think a lot of people would think, I'm not sure whether that's right or not, but they will think that the one which is made in Japan is better because it's coming from the country of origin and not from the country of manufacture. So that is again another intellectual property. So I think, with this particular example, you've come across all the 6 types of intellectual property that's there on the board. Now, coming down to the knowledge system, as I told you a little earlier, that what exactly is science, what exactly is technology, from where it came? It came from the traditional knowledge system. Now, the platform on which this science and technology, the modern science and technology developed, is basically a platform which was already there. And this particular platform is called the traditional knowledge platform or the traditional knowledge system. I'm not saying that this traditional knowledge system is something like, you can get rid of corona by drinking something like, which a lot of politicians are promoting. I'm not saying that. But what I'm trying to say is that there are a lot of these type of knowledge which have been used. Basically, they have been taken away by the Europeans, got experimentations and experimented on those plants or fruits or flowers or herbs and got a patent in that particular company's name. And then perhaps they started selling medicines all across the world and became millionaires. On this ground, without going deep into the various differences between traditional and modern, let's come down to this example. This case study is a case study of Rosie Periwinkle. How many of you people have heard of this? I think, not many, but this is I'm sure all of you people have seen this flower. Okay,
Yes.
this is very common, and it's found in almost all the areas in India, in the southern east of India, and also like in some of the countries in Africa. Now, you can Google it and you can see, and again, I'm sure you'll be able to recollect that you've seen that before. Now, this particular picture which is there on it, you can see that a line goes from India to the United States of America, and another one from a place called Madagascar and goes to the United States of America. Now I'll tell you exactly the story behind this. What happened here is that a couple of scientists once came down to Madagascar, and they were walking around, and they came across a particular tribe, an indigenous community in Madagascar, from whom they came to know that they use this Rosie periwinkle to take care of their digestive system. So they found this information very interesting. So they collect some samples, they goes to the United States of America, they got the things done, and they found that this particular plant have certain medicinal activities going on. And they developed 2 different medicines, okay? And they got patent on those medicines, and they started getting richer with that because those medicines work extremely well. Now, the question is, how about these people who are living in the indigenous communities, who actually have got that knowledge, who actually have been have been carrying on with that particular experience from their fathers and great-grandfathers, and they have been carrying on that particular legacy. So you are cheating on them because you're taking those information, and this is commonly known as biopiracy. And a similar thing happened in a very recent case, which is known as the neem case. And I think you can similarly see, like in this case, a lot of things were taken from India and the southern part of China, and they were taken to the United Kingdom, where they got patent in the UK Patent Office, and they didn't come back to India. They go directly to the United States of America, started making medicines out of neem, and sold it in the American market, and the products were an instant hit because there are a lot of lesser side effects in the existing medicines available in that particular area. Now, when India came to know about it, they objected, and after a lot of hue and cry, a couple of patents got rejected. So I see at least 40 in the US alone and 150 worldwide patents were made on neem. This is what you people I'll just reserve my comments on a greater extent, but just imagine the great biodiversity that we have, and what the faculties are doing in science and law. They are not collaborating together. They're not trying to develop mechanism by which they can create their own products. They can protect their own heritage and prevent these cases of biopiracy. I will just tell you another very recent case on this area, and that is about Basmati rice. Okay, I'm sure you people have come across this example, or majority of you people have. What happened here is that an American company, they got a patent from Basmati rice, and they started selling Basmati rice at a premium price. So India, Pakistan, all of them started shouting and telling that this is a rice which is for which our country is famous for. How can you say that it is yours, and how can you patent it? And they all objected. Now, there are certain rules. When you give an objection, you need to say that these are the reasons behind my objection. And there are certain practical standards set, like 1, 2, 3, 4, 5, 6, 7, 8, you have to say that, well, these things have been violated, and that's why you are asking for a violation of Basmati rice patenting from US. One of the criteria was that you have to show that there is a prior publication of the nature, type of Basmati rice, and the flavor and everything. You'd be astounded to know that India at that particular time had more than 17 public universities which are dedicated on agriculture. And none of them could bring even one published paper where they have written something on the Basmati rice. And hence, we failed to prove in the court, in the patent office, that it was ours. But with tremendous, support from many other countries and many other things, happened, there are political interventions, there are other things, and actually, in practice, even when we didn't win the case, there are certain things that prevented some American companies to start producing those things, and we had learned a very bad lesson out of this challenge. So when we're talking about the basics, the conceptualization of intellectual property rights, we need to understand that it is something which the Europeans, the Americans would love to promote in our countries, love to impose all of their inventions, their creations upon us, because we are the world's largest market. We are the biggest herd of consumers. Whatever they produce, we are the first people who'd like to experience. Whether it's a new iPhone, whether it's an update on that particular iPhone, whether it's a new, very cheap mobile phone with a huge number of features, we always wait for that to come. So the tagline that I'd like everyone to move on to today is to understand exactly what science in European countries and American countries have done to our world. If what's there on the screen is visible, I think you'll find it pretty amazing, and I'm sure some of you people have come across this. 90% of big fishes in the world have vanished. Now, very, very simple reason: overfishing. That's the only answer. Now, how this happened? This happened because of you people. How this happened? This happened because of the science and the technology that developed. And what happened? You have created nets which cannot be torn even by sharks. That's patentable, and that has been patented. And a lot of people are buying those things. Well, you people have created radars under the sea, so that if you put that radar on that particular boat, that boat would be able to locate exactly where the herd of fish is, and you go and take it away from there. So that's an amazing invention, I'm sure. But what has happened to us? This is exactly what has happened. Now, if you search more on the web, let me tell you, more than 30% of freshwater fishes have gone extinct from our planet. And what are we doing here? We are studying intellectual property. We're trying to think that, yes, it's important to go for patenting. It's important that we respect intellectual property protection, and we keep on doing that. We need more 5-star hotels. We need more 7-star hotels where we can get salmon, we can get hillside 24/7 and 365 days a week. Why? Because I have money. I'm a posh businessman, and I want that. I should be having it. Now, if this particular perception exists, I'm sure that the presumptions made by you scientists, many others, that by 2048 we'll have a complete empty sea and ocean, so there won't be any fish. So That's another prediction. They're based on science, I'm sure, and statistics and technology and everything. But what we have not followed, why has this happened? This has happened, ignored something which is called ecological ethics. Now, what is this term, ethics? And how does this apply in case of ecology? I'll give a small example to make you understand what this is. The tribal and indigenous people, they know, and even modern scientists, I'm sure they would be knowing them, when is the exact time when the fishes breed, these type of fishes breed, that type of fishes breed. So even when they used to catch those fishes, they used to leave those for future consumption. But today, the modern fishing is so critical and complex that they are way above ethics. They're way above ethos because they're running after the supply chain management. They have to give the supply to these and those companies within a particular span of time. Else, it's sad. Now, coming down to what you people can do. See, all the complaints that I've made so far is yes, to some extent against the scientists, against the technologists, but what you people can do. I think, with the Basmati Rice lesson, if I may be allowed to say so, I think it's important that we start publishing our papers and publishing more and more so that foreign companies, foreign people could not carry on this genetic piracy or biopiracy or simply take it away from you. Like if you have created an invention which you think can change the world, you need to give your best, and your university also need to assist you in getting a patent. Now, if you don't do that, somehow or the other, your invention would be leaked out and you'd be losing your right over that particular patent. So in order to have at least something to substantiate your claim at the long run, that yes, there has been a violation, and it'll be in a position of something in the court for the advocates like us to shout for you and say, yes, see, we have this publication and we can oppose that patent and we can revoke that patent. So it's important that we learn the lessons, okay? And so what we really need, okay, is to protect our work, our intellectual work, to the best possible extent. Whether it's a song that you people have sung, or a composition that you people have made on your computers, or anything, okay, a write-up, an essay, a poem, a song, an essay, a playwright, anything that I think it's important that you learn to protect them, because state cannot protect at this moment because of the existing laws. Okay, so you need to protect yourself. Even when some of us were working on this area of indigenous knowledge, tribal peoples and their rights, the traditional knowledge sector and everything, we have been struggling to by asking WIPO, the WTO, to make laws to protect traditional knowledge and traditional cultural expressions. But I don't think that they're going to do it so easily. So I think it's important that India should be making their own legislation which should be applicable within its jurisdiction, as Kenya has done, as Indonesia has done. So a sui generis legislation is something which I think might help the cause. And in that particular sui generis legislation, we might be having those ecological ethics imposed on people like you, on scientists who are promoting these theories, so that like your invention, your mind who is creating this invention would have something in your mind, in the back of your mind. Yes, That is also needed to protect our environment. That is also needed to protect our future generation. So your invention would be a future-proof invention. Let me tell you, everybody, that all the countries in the world, the member countries of the United Nations, have signed the Sustainable Development Goals. So we have this UN SDGs, which we are focusing on, which we are trying to promote. And if your inventions, if your work is purely something and which is not adhering to the principles, like, your work should be like, in furtherance of life below water. If you look at point number 14 on the screen, life on land, it needs to be sustainable. So everything that you do, okay, every invention that you make, every paper that you write, you need to keep these 17 things in your mind, in the back of your mind, so that it will be a future ready, because these are the 17 goals which all the countries, all the member states of the United Nations, including that of India, has promised to achieve by 2030. So we are in 2021. So another 9 years to go. So I think it's high time that our young, faculties, our young scientists, our young authors need to keep them in mind and keep on promoting intellectual property within. And I think it's important that there should be an incubation center in the university, which would help and assist, survey those publications, talk to the patent agents, try to get them patented, assist, because it's a very expensive process. So, there are many startup organizations who can be benefited by the expertise of the people who are working in your university, the scientists, their papers. They should not be there only in the libraries. There should be a working one, and which will definitely help our economy, not only their individual career or the university's career, but the career of our country, the career of our state in the days and years to come. So I think if we think in this way from the very inception, we teach our young people from the very inception in this direction, I think, we would be having a proper and balanced analysis between WTO and an organization which has not yet formed, which will take care of non-economic assets. So I think, that should also be in the back of our mind when we make our work and we proceed with everything that we do from now onwards. With that, I come to the end of my deliberation. So just in case anybody have any questions in their mind, they can raise those questions now.
Sir, I again seek permission. Could
Yes,
I
yes, please.
ask
Yes,
questions?
yes, yes. Yes,
So
madam.
first of all, this is absolutely brilliant, the points that you have made, and it kind of caveats perfectly with our university's philosophy, because we have just, we had a conference on blue economy.
Right.
We have been talking about conferences on SDGs. So this is something, and we do have an incubation center at our university. So it kind of, makes us very happy to say that somewhere along the line, we are probably going the way experts want us to. Okay, sir, but my question is, first of all, two questions. One,
Right.
you are talking about the protection of indigenous talent. Now, one big example could be Nolan Good
Right.
of Bengal. What we get now is a completely synthetic version, which is completely killing that entire ethos of that creation, and something it's absolutely unique in the world.
Right.
So, if we could get any ideas as to how to begin this process with knowledge reference, that
Yeah,
is-
I'll tell you, our university, the NUJS, has an IP chair, intellectual property chair. Okay, chair here means it's basically a sort of a small research center. Okay, and there is Dr. Ghosh, who is the chair professor in that, and we have, and they've collaborated with our center, the Center for Regulatory Studies, Governance and Public Policy, which is the nodal research center of our university. And we have identified across approximately 100 potential products for GIs. Okay, I think it's not only us or you who are trying to do something on similar lines, but there are many other universities. So if you look at the 17th goal that has been put up by the United Nations Sustainable Development Goals, which talks about partnerships, I think that is the best way forward. So if we can all work together, because you can well imagine we have identified 100 potential things. It is impossible for us alone to even work on 2 in 1 year with the work ethics and people that we have. So I think, and we have, like, if we talk about our IP center, we have gone to some extent with Barui Puripera, okay, but there are many other things that is there on the list, and I am sure that if we can all work together, we can have a very promising future in this particular direction.
Excellent, sir. I will keep that in mind, and let's see if we can work out something.
Yes. Professor Ghosh is also a very good friend of mine. I can also, we can arrange a meeting, we can have a discussion together, and we can take this argument forward.
Excellent, sir. Just one more question, sir. You were talking about sui generis legislation with reference to, let's say, Indonesia. But sometimes can't it backfire? Indonesia it's basically overrun by palm oil plantations, because couldn't it backfire environmentally? I mean, I don't know much, but
I'll tell you, the sui generis legislation that I was talking about is how we can protect our traditional knowledge and traditional cultural expressions. Okay, now, legally speaking, internationally legally speaking, the onus or the responsibility is on WTO and WIPO. Okay, they are not doing it. So how we can protect. Now, what we have done so far is that we have created something called Traditional Knowledge Digital Library, or TKDL. Now, TKDL is basically a library, and that's an open library. You can look into it. And say, for example, Mr. X, which is suppose a Russian company, who have already applied for a patent and got a patent on a particular thing, which is there in the TKDL as one of our ancestral knowledge or traditional knowledge, okay, system. So we can oppose by showing that. And this particular library is a growing library, just like that of your organizations or my organizations. Every year, some book or the other is coming down. Just like that, this library is enriching every now and then. So I think a sui generis legislation is required, whereby at least these type of things would be protected from being infringed within the country, if not outside the country.
Thank you very much, sir.
And that is the lesson I think we should get from. That is I think we can get from the Indonesian experience, from the Kenyan experience, and they have gone a long way. That their legislations have protected it.
True, that is very true. With Kenya particularly, it's excellent work. So thank you very much, sir. Very much for answering the questions beautifully, and it was a beautiful presentation. And Ashok sir, if you can go over.
See, if any participant wants to ask any question, you can write in the chat box, then you can ask your question directly. Any participant want to ask any question, if you are interested to ask a question, if you write in the chat box your name, then you can ask the question directly, or you can write the question in the chat box. Okay, so there is no question. There is on the participant. It is. So thank you, Dr. Shambhu Chakraborty. It was very interesting. And what that takeaway from my most interesting thing of your lecture, what we can remember and improve upon it, that you have explained very nicely the concept of ownership and the term economic asset. It is very interesting, and you have to work on that, the economic asset. And the biopiracy of the case study of neem, it is very interesting. And there are lot of many herbal trees available in our country or in our place. So we got inspired by your lecture that okay, we have to work on that. And as you
Right.
told, that even if we write a poem, that also is useful. Even if we write
Right.
a poem on any tree, that also you prove that the technology or the scientific use was known to our forefathers or known to us for long back. And
Right. Right. Right.
more think that okay, that your that what you told, that you have to increase our documentation of the indigenous variety of things. Okay, you have to increase your technique. Obviously, we'll be working on that. So thank you very much, sir. And thank you to. So with this, we will close our today's session, the food day session. So thank you all panelists and thank you all attendees. We will have next session on tomorrow at 5 o'clock. I request everyone to join 5 minutes before so that we can start in time. Tomorrow is our concluding day. So we'll have one presentation tomorrow. After that, we will have a concluding session. So thank you all.
Thank you so much, sir. Thank
Thank
you.
you. Thank you. Thank you. Thank you. So with this we'll close our session.
Hello?
Hello. Hello.
Yes, sir.
Hello.
Yes, sir, you were saying something.
No. It is over. It is over. I'm just waiting for the all the participant to dealing or the participant to disconnect. Okay, it is formally over.